Your Honor, I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do 2 trials at once.
The state could combine the trials and do 2 trials at once, but they don't want to do 2 trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases. Not to mention that they did combine all the discovery into one case. They didn't give me 2 different separate discoveries for 2 different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to do combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that.
with a normal defense attorney, and I don't mean that in any way, normally they would be severed.
Severed because you don't
to-
want one jury to know about the other
Correct.
2 separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date moved back to allow us to get the other witnesses lined up.
That's not what I was saying to combine them. I'm just saying give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6 is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try 2 cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we can get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd.
You said 21, 22, 23?
Correct.
Of May.
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a report, expert report, prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them. Was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
Of February 4th? Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion, was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on February 25th, so last week,
Okay.
a week ago. Anything else from the state?
No, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg thing and the shock vest and all that?
you're going to stick to your table and you can go to the podium, okay? When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay,
And if you need to hand a witness an exhibit, your advisory council will do that.
okay. Or my paralegal can do that too. or
Well,
whatever.
is your paralegal going to be present here designated as your, I guess they can be present. I'd prefer advisory council to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, so I'm going to be standing there, and if she's sitting here, she's going to come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it? just
Yeah,
the-
and there'll be There'll be a table or a cart here that'll have all the exhibits on it within reach of the podium, so.
Okay.
Anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that, so.
Do we need to have our exhibits in place?
All right, we'll see you at 8:15 on March 18.
So she can mark them.
Be at recess on this matter.
It's usually like a day or two. Like you could probably.
All rise.